It's Drive Time with Holly. Business and consumer news you can trust. I mean, what else are you going to do sitting in traffic?
Yes, and hello to all of those out there sitting in traffic on I-4, which, is probably every day, probably lots of them. There was a lot of traffic yesterday, I noticed. This is Drive Time with Holly. I'm Michael Yaffe.
And I'm Holly.
And we always talk business and consumer news. And today we have a pretty good, interesting subject because if you own a business, most likely you have employees.
Or if you get a paycheck from someone, you are an employee, which I think a lot of this information is going to be interesting from from both angles.
Well, yeah, exactly right. So we are going to talk with some experts on employment law. Later in the show, we're going to talk with some experts on human resources and how you deal with employees, the best way to do that. And it's going to be, so if you own a business or you're an employee, so pretty much like most of our audience, I think,
right.
is going to be really interested in what we're talking about. And if you have any questions, you can call 407-916-5400, or you can text to 23680. And Holly, we have a special guest today, don't we?
We do. We have Christina Mazaheri on the phone joining us. And when you're looking for an expert in employment law, you want to make sure that you get an attorney who knows what they're talking about and doesn't just dabble in this area. And so we appreciate Christina joining us.
Yes. So Christina, how are you?
Hi, Mike. I'm doing well. Thank you. Hi, Holly.
Hi.
Thanks for having me.
Yeah.
So you are an expert. Well, you specialize in employment law, right?
I have practiced exclusively in the area of employment law for the past 7.5 years.
So you don't just dabble, like Holly said.
I do not dabble.
You are full in employment law. Tell us a little bit about your background.
Sure. I am from a blue-collar working-class family from South Carolina. I studied law in Charleston, South Carolina, moved to Fort Lauderdale, where I worked with some employment litigators there for a year or so, then was recruited to come to Morgan & Morgan and have been with Morgan & Morgan for just about 7 years now. I'm in Kentucky, but licensed to practice in Kentucky and Florida and a number of federal courts around the country. I represent exclusively employees in litigation, and we do single plaintiff cases, class actions, wage and hour discrimination, medical leave, you name it.
There's not much she hasn't seen.
Yeah, exactly right. It sounds like it. So in dealing with, if you own a business, when should a business owner seek out an employment lawyer?
When do you most often see business owners land on your doorstep? Or, like you said, you typically represent employees. So the reverse of that would be, what case or what circumstances normally bring an employee to need your services?
Well, I'll answer that in two parts. The easiest answer is the second part of the question, which is the reason why someone calls me. 99.9% of the folks that call me are calling because they believe or they perceive that they've been treated unfairly at work. And usually they don't know if there's a violation of law. They just think that there's been some unfair treatment or immoral conduct on behalf of the company. Now, to answer the first part of your question, I would recommend that anybody that's interested in starting a business at least do a consultation with a qualified corporate employment attorney. And there's a number of those in Florida and, frankly, throughout the country that have great reputations that can, give you some piecemeal startup advice on things you need to look at when you're considering hiring workers and initiating employment policies, human resource type policies.
And
so the sooner the better.
Okay, but I'm guessing there's a lot of employers that don't do that, unfortunately. Do you have a lot of employers come more in a crisis situation than seeking out advice ahead of time?
Absolutely. And I think part of the issue is a PR problem in this country as a whole. A lot of small business owners or startup businesses think that, you hear the phrase at will or right to work. Well, this is a right to work state. A lot of people have this misconception that if you use those terms in your startup documents or your HR handbook, your employment policies, that you're really insulated from employment liability, and you don't really need an employment lawyer to get you going. So a lot of defendants that I get, it's their first time being sued. They had no idea. And, of course, it's a lot more expensive to deal with the issue on the back end than it is to, do a consultation with a qualified attorney up front and get some basics on what you may or may not be covered by with respect to federal, state, and local statutes.
So given that, what if you have to have a license to drive a car, you have to have a license to practice law, thank goodness. If more employers had to go through a new owner boot camp, and you were at the head of the classroom and you had, a few minutes with them to say, look, here's what you need to know. Here are the most common pitfalls that you're going to have with employees, or here are the things to avoid. What would you tell a new business owner?
Well, the first thing any new business owner should do is figure out if the size of their company is going to be large enough to be covered by certain statutes. Most federal and even local statutes have a cutoff at about 15 employees. So I can't say for certainty in every circumstance, but most legislation does not cover companies that are smaller than 15 employees. There are some other exceptions to that rule. Anybody over 15 is going to be looking at potential liability under a number of federal statutes that prohibit discrimination and retaliation in the workplace. Likewise, anybody that's got more than 50 employees is going to be subject to provisions under the Family Medical Leave Act and a number of other requirements. So I think what I would say, if I were teaching a class, is
you basically are right now to Orlando.
You got to decide how big you want to be. And I think one of the issues that I see in my practice is that some companies actually start really small. It's a mom and pop shop, and then they just do so well that they sort of grow outside their britches, and they don't realize that as they grow, they really do need to spend the money on competent counsel to make sure that as the size gets larger, that they are, that they're complying with federal, state, and local requirements with respect to medical leave. Some companies think it's okay to misclassify all their employees as independent contractors. That's a huge issue that I see in my practice, and one that I think a lot of small business owners and startups don't think is wrong. They might go to a conference and hear, oh, well, it's okay to just put everybody on a 1099 and no big deal. When in fact,
why? Oh, I was just going to ask, why is that not a big deal for those who don't know?
Or why is it a big deal?
Or why is it? Yeah.
Right. It's a big deal for a number of reasons. Number one, the employer is looking at potential liability under the Fair Labor Standards Act. So for overtime violations or minimum wage violations, those are things that when you classify someone on a 1099, you assume, most employers assume, that they don't have to pay overtime to somebody. There are other factors like workers' compensation insurance, discrimination laws, medical insurance, tax requirements. All of these things sort of tie into the employment context, and employers or corporate companies that think that, they can classify everyone on a 1099 may not be noticing that they're potentially violating a number of statutes, because the law doesn't care what you call somebody. What the laws look at is the actual working conditions, what the terms and conditions are. So just because you put a lipstick on a pig doesn't make it not a pig, right?
You were just full of great sayings today. I love it.
Well, thanks.
So if you're an employee who finds themselves driving home right now and they've been a contracted employee for 5 or 6 years and they go to the same job every day and, they work their 8 to 5 and the details of their job were handed to them, the expectations, the goals, etc., and they feel like, I think I'm not an independent contractor, but I don't want to lose my job. What do you, obviously, the easy answer to the question that I'm going to ask is that they should call an attorney and seek some representation or seek some help. But if they want to go to their employer and have a conversation and say, look, I think maybe my time as an independent contractor has passed. Would you consider, or I think it's time to consider maybe making me an employee? Walk us through what that conversation looks like. What does an employee have rights to?
Okay. Well, that's a bit tricky because not only, with rights come responsibilities. And when you just described the classic misclassification fact pattern. And when misclassification has occurred, both the employee and the employer could and most likely are going to be on the hook for back payment of taxes. Okay, so there's an issue there that needs to be part of the discussion. I'm hesitant to advise employees to go directly to their employer and talk about reclassification unless the employee is very comfortable with the individual that they're talking to and they know that the individual they're talking to is not being advised by counsel. Because the problem some of my clients run into is that they go to their boss in good faith to have discussions about potential, all sorts of potential violations. And then the boss turns around and takes it up the line to HR or to an executive who then takes it to their friend who's an attorney. And then there's a sort of a concerted effort to shield the company from liability while not necessarily protecting the interests of the employee. So yes, I do think that they need to contact counsel. They don't necessarily have to file a lawsuit, but it's not a bad idea to talk to an attorney, an employment attorney, and also in that context, maybe a tax lawyer too, about what the ramifications might be.
And we are talking with Christina Mazaheri, who is an employment law attorney out of Lexington, Kentucky. She's telling us about employment law. A lot of people probably don't know the details of this. If you're an employee or an employer, this is information you're definitely going to want to pay attention to. So we're going to continue our conversation with her. You're listening to Drive Time with Holly. I'm Michael Yaffe.
And I'm Holly.
And we will be right back.
Welcome back to Drive Time with Holly. Business and consumer news you can trust.
Yes, good evening, everyone, and welcome back to the show. It's a beautiful day in Central Florida.
Yeah, roll your windows down.
Yeah, you should roll your windows down. I mean, not too far because you want to still be able to hear the show.
Right.
This is very important, but it's definitely a beautiful day outside. You are listening to Drive Time with Holly. I'm Michael Yaffe.
And I'm Holly Sammons.
And we have been talking with Christina Mazaheri, who is an attorney for employment law.
Right.
And she's been giving us a lot of great information, especially on how to deal, if you're a business owner, how to deal with your employees, how to do the right paperwork, and what to do if you feel like something is not being done right.
Right. And Christina made the point earlier that if you're starting a business, most certainly if you're growing your business, you want to get some employment. You want to have an employment attorney give you some advice on how to set things up properly. Because believe me, doing things the right way the first time is going to cost you a whole lot less money and heartache than if you try to clean up your mess.
Yeah, and she said that was one of the biggest mistakes is they wait until
it's too late.
It's too late.
Yeah, until you're in trouble. Right.
Exactly right.
And, just because you know your trade really well, just because you're an excellent plumber or you're a really wonderful businessman or woman, you run a top-notch roofing business, no one expects you to also be an HR and employment law expert. So there is no shame, and certainly it is not considered lavish spending to get some advice to make sure that you've properly protected yourself and your business, because ultimately, if you properly protect your business, you're protecting the livelihood and the source of the paycheck for your employees. So you're really, doing everyone, doing what's right for everyone.
And yes, and we are already starting you down that path because we are talking with an employment law expert and give our audience some great information, and we'll continue with that.
Yeah, one question I wanted to ask Christina was, and I'm gonna just kind of spit it out there, and I may not ask it the right way, but I know you'll straighten it up for me. Towards the end of last year, under the Obama administration, there was an executive order reference exempt employees as it relates to income level, and are you truly an exempt employee? Should you really be hourly? Can you give us an update on where that is and how it applies to our listeners?
Sure. Okay. So the Obama administration attempted to raise what's called the salary threshold for what we call workers who are white-collar exempt employees. There are three main categories of white-collar employees, and these include executive, administrative, and professional workers. Good examples are doctors, lawyers, teachers with degrees. Certain IT professionals can be exempt as well. Administrative exempt professionals might be people that are like HR managers. But the first requirement for all of these exemptions is that people make a certain amount of guaranteed salary each week. Now, the Obama administration attempted to raise the level of that salary. It was $455 before. He attempted to raise it into to the range, I believe, of $700. And he had issued a regulation to that respect, or an order to that respect. Now, that's been blocked by the courts, so it's not going to go into effect right now. But I think the bigger issue, and this was an issue even before the Obama administration got involved in this, is that a lot of companies think that when you give somebody a fancy management title and you pay them a flat salary, that you can work them as many hours as you want without having to pay them overtime. And, just because you do those things doesn't necessarily mean that those workers aren't entitled to overtime. For example, the law looks at both the salary requirements but also the job duties of the individual. And the Fair Labor Standards Act, which is the law that governs these exemptions, really was intended to provide overtime payments for as many workers as possible. So the white-collar employees really should be a very small percentage of the American workforce. And I think employers try to overutilize those exemptions. So as far as the status goes, we are still at the status quo where we were before the administrative order from the Obama administration. But I'm still seeing tons of violations with respect to misclassifying workers as white collar when in fact they're not.
So let's say I come into work every day and I'm an assistant manager to a store, and really my only management responsibility is I set the schedule for first shift. And I make the schedule for first shift. And really that's my only management responsibility. Am I truly a manager?
Well, it's going to depend on where you file your lawsuit. As you know, the law that Congress writes is one thing, and then the way that courts interpret that law is something wholly different. I will say that Florida is one of the more conservative districts. So all you business owners out there, you can rejoice in the fact that you're going to get a more conservative judiciary in Florida than you would, say, in California, for example. But that said, every court has to look at every single case on its own facts. So we're going to ask questions. If I'm the judge, I'm going to ask questions like, did you sign orders for your company? Were you receiving shipments? Were you signing contracts? Were you the one handing out hiring documents when new employees came in? Were you doing those things in addition to your scheduling duties? There are many different ways a court can determine whether someone's exempt or not, and it really is a fact-specific inquiry to each employee at each workplace.
And is calling someone a salaried employee and calling someone an exempt employee, as it relates to this, are those the same thing? If I say, well, I'm salaried, and yes, I end up working about 60 hours a week, but I'm on salary, so it is what it is. Is that the same thing we're talking about here?
No, but I think a lot of people think that it is the same thing. I know that a lot of employers are surprised when they might get a letter from me saying, hey, I believe you've misclassified my client. And they'll say, well, I pay your client a salary. We had an agreement. And they just think that their agreement governs. Well, it actually doesn't. The Fair Labor Standards Act has a provision that says you cannot contract out of the right to overtime and minimum wage payments. So that means that just because you say that someone's salaried, and just because someone agrees to be salary, doesn't mean necessarily that they are white-collar, exempt under the statute.
Mm-hmm.
Do you feel that there are, what businesses do you see this happen a lot?
What industries?
What industries does this happen a lot where they miscast them as salary when they shouldn't? Do you see a pattern in certain industries?
I think that there are a lot of misclassification cases that involve, say, mortgage underwriters or folks that work for insurance companies. You got to think of, some of these, I call them mega corporations, right? They're the largest corporations in the country who have the ability to lobby Congress and sort of set the standard for the rest of us. They have very smart attorneys who are figuring out ways to tweak their policies so they can classify large swaths of workers as as exempt employees. And in doing so, they're retaining, in some cases, billions of dollars in wages that otherwise should go to their workforce. And I'm talking about huge corporations nationwide, in some cases international. So, yeah, mortgage underwriters are one. The banking institutions oftentimes do this, and I don't want to pick on anybody in particular, but those are some industries that that we see those violations in. Healthcare industry is another one.
Right. And so we wanted to talk about that tonight, not necessarily to raise the blood pressure of our business owning listeners, and to say that, everyone should rush to their computer and file a lawsuit. But knowledge is power. And when you know better, you do better, in theory. And, it's our hope with this show and with sharing this information that business owners and, management, maybe you're an office manager and your business owner relies on you to help make these decisions. So the more you know, the better you do. Christina, I have one more question. So what rights do employees have that are commonly misunderstood?
I'd say probably the two most common issues are employees thinking that they cannot talk about their pay with other workers. Some companies will actually have a policy that says you're supposed to keep your pay confidential. Those kind of policies could violate a number of different laws, one of which is the National Labor Relations Act, which most people think about as a unionization law, when in fact it applies even though there may be no union. I know there aren't that many unions in Florida in the private context. So workers have the right under that law to get together, to talk about their pay, to complain together about working conditions, say safety, for example. And they're allowed to do that without fear of retaliation under that statute. And if they are retaliated against, they have certain administrative remedies that they can take care of. But I think, to go back to the point about raising blood pressure, there's one thing I think that needs to be made clear. There are a number of wonderful resources to both employers and employees outside of the litigation context. There are federal and state agencies that will work with employers and employees in investigating complaints, remedying potential violations. And most of these statutes have what's called a liquidated damages provision or maybe a good faith defense. What that means is if an employer didn't realize they were doing something wrong, but then they went and tried to make it right, then they're going to reduce their monetary liability on any potential claim by doing the right thing as soon as they possibly can.
Oh, that's really good advice then. So for those who are afraid to get into it because they're afraid of being exposed as doing something wrong, you would encourage them to fix the problem now because there'd be less liability in the future.
Yeah. What it is don't be afraid to be exposed for doing something right.
Very, very interesting.
It's great PR.
All right. Well, we've been talking with Christina Mazaheri, who is an employment lawyer, an attorney in employment law, and we really appreciate you informing our audience, our employers and employees out there on what best practices to do when you're running a business in this area.
Yeah, and we're going to share some more information, some follow-up about what Christina's talked about, give some more details on our social media. You can go to drivetimeholly.com, and we'll post some follow-up resources, and we'll also track down some of the resources she mentioned and put it all there so that if when you get back to your computer tomorrow, it's something that you'd like to look further into, those resources will be there for you. Thank you so much, Christina.
Thank you both. It was a pleasure. Thanks for having me.
Thank you.
All right, you're listening to Drive Time with Holly. I'm Michael Yaffe.
And I'm Holly.
And we'll be right back.
Welcome back to Drive Time with Holly. Business and consumer news you can trust.
Yes, and I'm Michael Yaffe.
And I'm Holly.
And welcome back to the show, everyone. So that was a really informative conversation we had in the last couple segments dealing with employment law. And I bet there are a lot of business owners or employees who never really even thought about that, going to see a lawyer for anything like that.
Yeah. And, I think even I could see just watching you during the segment, I think it was more interesting than you even expected it to be because we don't realize
That's what this show has been like, actually, in general.
We really just write it for Michael.
I've learned so much. I say that every week, but it's true.
But, most of us, if we're lucky enough, are either an employer or an employee. And, we can do a really great job at what we do. But if we're not good employers, if we're not educated, informed employers, or if we're not employees who are also informed, when there's gray area, when there's misinformation, that's where you get into trouble. So I think knowledge is power.
Yes.
And
for both, like you said, the employees as well.
Right.
There are probably a lot of employees that are being misclassified, and they just kind of go along with the flow, don't think there's anything they can do, and now they know they have options.
Yeah, it's a conversation starter. And look, we acknowledge that if you feel like you may be misclassified and you need your paycheck and you can't afford to rock the boat, we get it. We're not trying to say that you should, pound your fist and walk away from your paycheck when that's what's paying your bills. We acknowledge that not everyone is in the position to make a change or make a difference, but the more you know.
Right. And in speaking in this area, dealing with employees, another area that employers and employees have to think about is human resources, employer and employee record maintenance.
Yeah.
So there's no doubt there's a lot of records that are kept in any business.
It's not a sexy topic, let's be honest. But the reason this came up was because, honestly, in my office, the bookkeeper in the office said, I need more file folders. And I said, more file folders? Yeah, I need another pack. Well, a pack is 100. I said, you need 100 file folders? Yeah, I do. And so I went in to kind of open the cabinets to see. And it all just fell on top of you? And right. You're in a sea of records? She does an excellent job. It's all very neat and tidy and well labeled. But, many of us are going paperless. I know, I have a desk that has very little filing storage.
Yeah, so, I'm like that here.
Right. So it just blew my mind that she needed more file folders. When I looked at what she was working on, she said, these are all things we have to keep. I said, let's call Linda. Let's call Paychecks and ask the question. So here we are.
Yeah, and we have two representatives from Paychecks. We're talking with Linda Lucarelli, who is the human resources consultant with Paychecks, and Stephanie Lobish, who is our human resources generalist. And, well, how are you guys this evening?
Great. Thanks for having us.
Thanks for coming in. So when we have employees, you put out a job posting, you take applications, you hire someone, you retain that employee for hopefully a number of years. They put in PTO requests. They have payroll deductions. They have all these pieces of paper that get put into a file somewhere. So let's start with, as an employer, what does record retention look like, and why is it important?
Great question. And it really is generally the start of hiring a new employee, because you're going to have that documentation, like you mentioned. Technology, I will tell you, in the last few years has changed client retention for employers in a tremendous way. So the cloud-based systems that are out there, an HRIS database, a lot of technology, and you just basically do your electronic files. So a lot of stuff is done where maybe the employee would go online and fill out forms, and it's in some kind of database. So there's still requirements to make sure that you have security and confidentiality really in that process. But generally, if it is paper, which most people do still have, especially small business and employers where Paychecks, does a lot of our business, is that a lot of it is still not necessarily automated for them. So in general, the question, Holly, I wish it was an easy one. It kind of depends.
Yeah.
It depends on the document that you're collecting from that person or that employee. And it depends sometimes on the employment law of where you need to keep that document and for how long.
Okay.
So in general, you're going to have a general personnel file for an employee. And you're going to have the application, references, things like that, maybe a job description that you may have them sign off on, policies, procedure, handbook, or anything that might be specific to that. Any kind of performance appraisals, performance management, discipline, maybe write-ups. Those are going to be in that general file. And you want to make sure, and really the honest truth normally is that you do, for PTO requests, a lot of that is automated now. Mm-hmm. Do you need a PTO request from 2004, which you had mentioned?
Right.
No, you're probably not going to need that document. And again, a lot of these are more automated in the future and stuff. But I think, you just want to make sure that you have a very, core document of that application process and them coming into your door of your business.
Right. So my employee file, I mentioned to Linda during the break, my employee file is like the size of 4 Encyclopedia Britannicas, and I'll tell you what that is during the break, Michael.
I know what that is.
Yeah. So it's huge, but it's because It's because I have PTO requests from 2004. I've been with Better Business Bureau for 15 years. So I've asked for a few days here and there. And because to err on the side of caution, I think, we've kept every scrap of paper in my file. So when it comes to purging, I think it's helpful to be able to provide people with, and that's one thing that we'll provide on social media after the show, is kind of a list, a good general list of what you keep and how long you keep it. But so you're saying that my PTO requests, how long, once that's been signed off on and approved, how long are PTO requests, something as simple as that, how long are we keeping that in the file?
Well, it brings up a couple of questions, because the question might be, what would you need that document for in the future? And Christina kind of mentioned a little bit about wage and hour. And, certainly Paychecks does not provide legal advice like Christina does. We're not licensed attorneys. But we do have best practices to communicate to our clients on how to retain those documents. So a lot of it just really kind of depends on the document. You may need that document for wage and hour purposes. Again, if maybe somebody was stating I was not classified correctly and you took a vacation or whatever, or didn't pay them overtime or several different things, you may need that document. So I think it depends on the law. Generally, with Fair Labor Standards Act, you want to keep those records for at least 3 years. Okay. So that's kind of a standard there. The other piece of documents, which is very important and it's a big topic of conversation right now, is your I-9, which is your immigration documentation. So every employer is required to have the I-9, which basically states that the employee is who they are. So I am who I am, which is identity, and I'm able to work in the United States.
And that's applied for every employee.
Every employer, yes. And you are required to keep that in a separate file. So that should not be part of the personnel file. And I think sometimes businesses may not know that.
But can there be an I-9 file that has everyone's I-9s in it?
Yes, you can have a booklet, notebook, however you want to organize it. I would encourage you to keep all the I-9s, your current employees, and you are required to keep past employees. I think a lot of times we think, okay, the employee is gone, so we can ditch that, put in the personnel file and, of that terminated or maybe exited employee, and that's not necessarily the truth. So again, with the I-9, you're required to keep that 3 years past the date of hire or 1 year after date of termination, whichever is greater. Okay. So there's a little math you got to do. And even though they're terminated, you want to make sure that you maintain those. And they can be, normally what I kind of suggest to a client is have your current employees and then have your termed employees, whether it's in a file or notebook or whatever. So you're able to kind of map that out when you can purge and actually shred that I-9 if you're past that particular time.
So I actually want to back up here just a little bit. And Stephanie, maybe you can answer this question. When we say paychecks, we say you work for paychecks. There's probably, our audience probably has no idea what that is unless their business uses it.
Right.
Tell us a little bit about Paychecks, the company you work for.
Sure. So Paychecks provides anywhere from HR services to payroll services. Most people think of it as a payroll provider, but we do offer workers' compensation, health insurance. We have a PEO product under the Professional Employer Organization. And then we pretty much serve as, a liaison between all the different types of products that an employer needs to use. And we take care of all the administrative duties for that client. We also provide in the HR services area the guidance and the best practices for the employer.
And I can definitely understand why someone would want to use a company like Paychecks, because you're giving me a lot of information that I didn't know, which is why they have you.
Yeah.
So you know that stuff. So when they're dealing with situations like this, like record maintenance, they can go to you for that advice, and you obviously know the answers. So that's good. So we're going to get more answers from you in the next segment. We have a lot more questions on this subject. You were listening to Drive Time with Holly. I'm Michael Yaffe.
And I'm Holly.
And we'll be right back.
Let's be better consumers. You're listening to Drive Time with Holly.
Yes, and on this episode of Drive Time with Holly, we're talking about maybe how you can get out of the pile of records and folders that are in your closets at your business or filing cabinets or wherever they are, right, Holly?
Yeah, or maybe you hang on to them with white knuckles.
Yeah, this is very true. So we've been talking with a couple of experts from the company Paychecks on dealing with employer and employee record maintenance. We're talking with Linda Lucarelli and Stephanie Lobish, who work with the Human Resources there. And we actually have a question from a caller on this for you two. And so let's take it. Cindy, how are you today?
Oh, excellent. Thank you, Michael, for taking my call. I really love your show.
Oh, great. We love that you're listening. And so what's your question for our experts?
What would be for flex spending? How much can you put in?
That's a great question. And generally each year the IRS sets those standards and set those limitations for the flexible spending account. And
before we continue on, what is a flexible spending account?
A flexible spending account is a pre-tax account that you can put dollars away that are pre-tax up to a certain limit for either healthcare expenses that are out of pocket, meaning copay, prescriptions, deductibles, things like that. And then also there's another portion of that which is dependent care, and that could be your daycare expenses. So what it does is allow you to put a certain amount each year. There are certain guidelines because, again, this is an IRS pre-tax plan, so you have to be very careful about the administrator or whatever the plan states as far as use or lose, because it is a use or lose plan generally, unless there's other kinds of stipulations with a rollover or whatever. But in general, I believe it was going to be $2,650 for 2018.
So the employee doesn't set their own threshold. They don't set their own dollar amount unless it's lower than the max. But they can't say, look, I know I've got 2 kids in braces and I've got 1 kid that breaks at least 1 arm a year. So I'm going to go ahead and set my FSA at $10,000. You can't do that.
No, you can't do that. And again, remember, you're paying for that. So you don't get taxed on that, which is great. But you are paying for that, meaning that it is deducted from your payroll at a pre-tax benefit. But there are basically, and you want to maybe contact your employer to see what their adoption agreement looks like and exactly what limits they do, because they have a right to do less than what's required.
One thing that's always kind of confused me, what's the difference between this and like a health savings account? Seems like the same thing.
Great question. There's a lot of talk about that. The health savings account is a little bit different because it is your account. You can actually take it with you when you leave the organization.
Oh, okay.
The flexible spending account is a company-sponsored tax incentive for the employees to be able to put money away for that. So it is different in the health savings account. But generally, there are provisions. Again, not everything is so simple on some of these laws and programs, is that generally it's with a high deductible plan. So if you go to another employer and they don't have a high deductible plan, then generally you can't use that health savings account. So there's always, there's pros and cons with each. And you have to, but the nice thing with the health savings account is that it's your money. It's basically, a checking account or a debit.
And it doesn't go away at the end of the year.
Right.
And is that if my employer offers, or if FSA is available, is HSA, is the health savings always available too, or is it typically one or the other?
Yeah, it's generally one or the other because both of them are pre-tax plans, so they don't like to necessarily double dip all the time.
Right. So we have a question that I think is a question that employees are afraid to ask, because when you're sitting at maybe the HR desk or if you're in a business that's small enough that there isn't an HR desk per se, there maybe is an office manager, or you're going straight to the owner's desk. What are employees' rights as far as do they have a right to see their files? Do they have a right to you pull that file out and I'd like to look through it? If I do have that right, do I have rights to make copies of what's in there? What's that look like?
No, great question. We get this a lot. Absolutely. I mean, we take the advantage of saying that we want an open relationship with your employees as far as communication.
Transparent.
Yeah, absolutely. Because the more open you are about, your policies, procedures, what employees' rights are, and, training and things like that, the better relationship you're going to have with them. So you might not have employees, if you're doing the right thing and following the guidelines and the laws, have employees that feel like they might be mistreated or have maybe a law that was against them. So in general, a policy would always be good for, your handbook that states when they're able to look at it once a year, anytime, they have to make an appointment, whatever you want to put down as the employer. From the perspective of client records, they do belong to the company. So they don't belong to the employee.
So
they belong to the company. Not necessarily. That's up to a company to determine that. I don't know if I can't give you legal advice, but I wouldn't probably, give an employee their file. So I certainly think that they can look at it and have a conversation, and it shouldn't be anything that's a surprise in that file. That's really important. If somebody's been disciplined or are written up, hopefully there's some kind of signatures in there and they know that that's in that file. So it shouldn't be any surprises for the employee.
Are there any records that the employee should keep for a long period of time?
No, not necessarily. I mean, they may be doing some things on the side and taking notes of their hours and things like that. But generally, the record keeping is the client's responsibility for, whether it's hours worked or benefits administration. Obviously, documentation for, discipline or performance is generally the employer.
So should I be keeping my pay stubs?
That is up to you. You may need it for tax purposes.
I look and I shred it. And, there are some people who they look and they shred it. And then there are other people who keep them for years and years and years. And the people who keep them for years and years look at me like I have a horn growing out of my forehead. Like, what are you doing? What's the rule?
Yeah. No, there is no rule on that. I mean, you may need those records, which normally, obviously, you can go to your payroll department or HR department to get those records. If maybe if you're applying for a loan or something like that, you might need that documentation for purposes. But do you need your pay stubs from 10 years ago? Probably not. Again, the other thing, too, is, paychecks of most of the companies that are out there. I mean, we have, a lot of technology where basically you can see your records online, and we have mobile apps and things like that. So you're able to pull that up as needed.
Great.
So we are just flat out of time. We could probably
I told you it was interesting.
We could probably get like hours worth of information from you. But if you want to find out more information on this, just go to our social media page, like the Drive Time with Holly Facebook page. I'm Michael Yaffe.
And I'm Holly Sammons.
And we'll catch you guys next week.